Thank you, Vedras. Opening a session after the lunch is a pretty difficult task because it's like facing up to Dale Steyn on a very humid Durban pitch in the morning. Now I'll try to make a very brief presentation so that you don't fall asleep, and let me try to make a few points that I felt as a public law person, as a teacher who deals primarily in constitutional law, certain points that I felt are lacking in any privacy initiatives, any initiatives towards legalizing, towards legislating on privacy. So when I talk about surveillance, I am not talking about state-made surveillance per se. I am talking about surveillance, interstate surveillance among citizens. So when I am talking about surveillance, I will largely be talking about the paparazzi, the way the celebrities' rights get trampled, the celebrities' privacy gets trampled, and what has our legal system to offer. So I would begin my presentation, and Aditya will help me in this, with just trying to streamline privacy as to whether it's a question of legitimacy. You see, we all know that we have a fundamental right to privacy, call it a part of 21, call it a part of 19, but we do have that. But the problem is, all of us know that the courts have very severely limited this fundamental right to privacy. Privacy not being absolute, privacy being trampled in the interest of other greater common goods, and so on and so forth. Now in that situation, what we have ended up with is a situation where privacy needs to be legislated upon. Now we had these several versions of the privacy bill, some of which was leaked. I think all the different drafts have been leaked in some points of time or the other. Now if you look at one of the draft versions of the leaked privacy bill, you find that there is a cursory reference to right to privacy. But interesting enough, that reference is, in the first draft, it was every citizen shall have a right to privacy. Subsequently, citizen was changed to individual. And individual is defined as a citizen of India. Now, if we say privacy stems from 21 applies to all persons, not only to citizens. So even a non-citizen has his right to life and personal liberty. If we construe privacy as an element of personal liberty, then we have a law which grants right to privacy only to citizens. Now that constitutional issue apart, there is another problem, that this law, insofar as it talks about right to privacy or granting right to privacy, this law is primarily aimed at surveillance. So in the beginning, in the first few sections when right to privacy is talked about, the rest of the act is about surveillance and legitimizing surveillance. So one stands to wonder as to whether this is a law which gives a recognition to privacy, or it is a law that gives recognition to curbs on privacy. Now leaving that aside, that one draft of the draft privacy bill also creates a very interesting inroad for journalistic purposes. That your right to privacy, whatever it is, can be curbed for journalistic purposes. Now it is again a very interesting formulation that I will come to very briefly. We see that our laws, or for that matter laws of any other parts of the world, privacy becomes a very serious issue when we are talking about a celebrity's privacy in light of the celebrity's publicity rights. That if you are a celebrity or a public figure, you have been given certain rights of publicity, essentially proprietary in nature. And since you have got certain rights of publicity, you have to make certain compromises on your privacy. That is the linkage to privacy that is drawn in many countries, not just in India, when we talk about celebrities or public figures. Next. Now, even when defining the public figure, there is a small dichotomy that we face. The American courts, in this interesting case called Martin Luther King Jr. Center for Social Change, has defined a celebrity for right to publicity purposes in a very interesting manner. What it says is, when an unauthorized use of a person's identity is made that is direct in nature and commercial in motivation, that person whose identity has been misappropriated becomes a celebrity for right to publicity purposes. Now look at two things. First of all, we are talking about a right to publicity oriented definition of a celebrity. And secondly, we are talking about an element of commercial exploitation, which again comes in when we talk about publicity rights. This is as if to say that your definitions of celebrity or your definitions of privacy will exist only when we are talking about a commercial exploitation. In the previous session, Madhavi was making a very interesting point. She said that privacy is a value in a democratic society. It does not depend on an individual, who that individual is, whether this individual is a public figure or is like any one of us. She was making a reference to this English case, the case of Peak, where this person was out in the road, and out in the road the state would argue that his reasonable expectation of the private space gets automatically curtailed. But the court still held that he did not expect the surveillance agencies to keep a tab on him. So his reasonable expectation of privacy had to be kept at that level. Now when we are talking about privacy as an intrinsic fundamental value, a constitutional value, then how are we defining privacy solely in terms of the commercial element of it? Now this is a question, this is a lurking question that I want to deal with. Now the Indian test for public figure is also a very vague test. We have a tautological formation, public figure because of public attention, so whoever has public attention becomes a public figure. We had in NUJS versus Forbes a kind of a definition which said that persons whose standing, accomplishment, fame, mode of life or profession gives a public a legitimate interest in their affairs becomes a public figure. Now I don't know whether by this definition Asaram could be called a public figure, because his standing, accomplishment, fame, mode of life or profession is not something which a typical definition of a public figure would normally entail. And interestingly, you have no public figure by affiliation. In A. Radha's case, A. Radha versus P. Srinivasan, his relatives, Radha's relatives, they were specifically excluded from the list of public figures. Public figures would also mean celebrities. Now, going by that logic, do you say that a Robert Vadra is a celebrity or a public figure? Do you say that an Aradhna Bachchan is a public figure or a celebrity? Now, why I am asking this question is because the moment we come to celebrities, the natural response or the natural point that the media makes is that if you are a celebrity, you should have a lower degree of a reasonable expectation of privacy than the rest. And anyways, you are getting right to publicity. You are getting a right for full commercial exploitation of your person. So in a very proprietary manner, your reasonable expectation of privacy, and that is a term that keeps coming back, gets adequately lowered the moment you become a public figure by definition. So naturally these questions do arise that whether you can become a public figure by affiliation. Okay? Next. More importantly, another reason that the newspaper or the media gets in violating the right to privacy if you are a public figure is the element of newsworthiness. Saying that not only reasonable expectation of privacy, being a celebrity, you are also a newsworthy commodity. So that element of commodification does definitely come in, which says that since you are newsworthy, since people have a right to know about you, and since it is a manifestation of the people's right to freedom of speech and expression, right to know about you, right to know about what's happening around, therefore you cannot probably claim your right to privacy. Now I will give you a few examples to figure out whether newsworthiness could be even defined or could be even straitjacketed. Before that, move to the next slide please. Before that, the journalistic part of this, which can breach your right to privacy, here's a very illustrated list that is given in the draft privacy bill. It says that reasonable expectation of privacy assessments, any one or more of the factors need to be present. Now, if you look at the factors, you will see that they are extremely vague ones. So, one cannot really make out as to the presence of one of these factors can act as a mitigant, can act as something that can allow a legalized violation of your privacy. These questions remain very blurred, the lines remain very, very ambiguous, very blurred, which the subsequent slide will show. Ranbir Kapoor and Katrina Kaif enjoying in Ibiza, southern France. Do you see an element of reasonable expectation of privacy here? Could you leave them alone, or are they newsworthy items to be published in Indian Express and all newspapers and Stardust the next issue? Can you move to the next slide? And this is what Katrina Kaif does. She writes a very scathing letter to the media. A very interesting part, a very important part in that letter is there is a breed of journalism that preys on celebrities in the worst possible manner, crossing all lines of privacy and decency, which she definitely seeks to target, which she definitely seeks to criticize. But for the journalist, it is a simple matter of newsworthiness. People are really curious to know whether they are a couple or whether they are holidaying together. Now, where do you draw the line? Can we move to the next slide? Priyanka Chopra in her father's funeral. This photo, which is again taken from Indian Express, has Priyanka Chopra, naturally in a state of shock, her father has passed away, being consoled by Shah Rukh Khan. The next day's news tabloids, the next day's, there are certain news channels which also I consider them to be news tabloids. They have headlines like Priyanka ko rahat mili Shah Rukh ki baaton mein. And naturally, there is an element of, a very curious element of extramarital, because Shah Rukh Khan and Priyanka Chopra was story for some time. There is a very curious element of an extramarital relationship being drawn in at a situation when this poor woman is grieving because her father is no more. Now, do you think Priyanka Chopra had a reasonable expectation of privacy in this circumstance? Do you think because Priyanka Chopra happens to be a celebrity, that reasonable expectation of privacy gets lowered even if her father has passed away? Or do you think it is such a newsworthy thing that Priyanka Chopra's father has died and Priyanka Chopra is standing in this white sari and being consoled by Shah Rukh Khan, that there can be such media reports? So again, newsworthiness is a standard which seeks very demanding questions. Move on. Now let me come to the third prong of my presentation, which is, are we technologically competent to handle such interferences, be it a celebrity or a non-celebrity? I have given a reference to the California anti-paparazzi law, which talks about a very interesting distinction that it makes between two kinds of invasion of privacy. One is a physical invasion, which necessitates an actual act of trespass. The other is a constructive invasion of privacy, where you use visual or auditory enhancing devices, regardless of actual trespass. So if you are using a high-power zoom, high zoom camera and invading your privacy, even that can be deemed as a constructive trespass or a constructive invasion of privacy. Of course, that law also necessitates a commercial motive behind such an exploitation. But what that law does is it gives a very inclusive definition of a private, personal and familial activity, which has things like, it also talks about a reasonable expectation of privacy, but it widens the net to cover things like intimate details of personal life, interaction with family or significant others, activities in a residential property which is defined as a residence, hotel, inn, lodge, etc. Other aspects of his private affairs, and it does not include illegal or criminal activities. And this law also talks about when there is an actual or a constructive invasion of privacy, there is a limit of fine that is to be paid, and half of that fine will be utilized towards promoting the arts and entertainment fund. So in a way, you are kind of legislating on an invasion of privacy from the angle of the state, from the perspective of the state. Not purely, even though the starting point is a commercial exploitation angle, but your appreciation of privacy is not only limited to whether privacy is a compromise for publicity, it goes beyond that. Maybe that is something that Madhuri was trying to relate to in the presentation. Next. Now, how far are we competent? I am not getting into these because there is a statutory and state sanctioned intrusion. We have heard about the CMS, the CCTNS, NAT-GRADE, TCI, SEYD, all of these, and I'm sure we have very eminent speakers who will be talking about that. But the media stressed with modern technology, the media getting hold of the new technological innovations and advancements, is also creating for this space for yellow journalism. The amount of Indian paparazzi has enhanced, has probably doubled, trebled, has increased many folds in the last few years. And that has got a lot to do with, MMS, good mobile phones with high resolution cameras, and a lot of such technological advancements. Now, are we prepared for handling this? Next. I would suggest that self-regulation is a way out. More than the state trying to legislate, state should legislate on a democratic level, on a democratic basis, not on a commercial basis as such. All our focus towards legislating or legalizing right to privacy has been right to privacy as a commercial compromise that you have to make because you are getting certain dividends in the form of publicity rights, which is something I think is trying to look at privacy in a very skewed manner. So I feel that any legislation on privacy has to be done on a more society-centric manner rather than looking at just one aspect of privacy, which is the commercial aspect. But the media also should self-regulate. And this is one example of self-regulation that I could find out. This is the NDSA, the guidelines that they offered to its members, and it was a mandatory guidelines, and I'm told that the media had scrupulously observed that guideline when they covered the birth of Aradhya Bachchan. The guidelines include things like no pre-coverage of the event, story of birth of baby to run only after and on the basis of official announcement, story not to run on breaking news band, and several of such things. Now, if such a detailed guideline on an event-specific manner can be handed over by a self-regulatory body, which is followed largely by its members, I think that is the best kind of self-regulation that is possible. That is, in fact, the best kind of regulation that is possible. Next. So finally, what do we have? As I look at it, again from a very constitutional perspective, I do not find a constitutional angle to privacy. All that I find on privacy is a purely commercial angle, a purely commercial exploitation perspective that I look at privacy from. So I feel that when we're talking about the proprietary values of privacy, we should also not lose sight over the intrinsic value of privacy as a constitutionally protected imperative, as a fundamental right by itself. And I feel that these standards like reasonable expectation of privacy is a very open-ended thing because it can be clearly surpassed by newsworthiness requirement. Now what allows for this surpassing is that newsworthiness has a constitutional backing. Privacy probably does not have a constitutional backing. They're still trying to trip and grip on the constitutional backing, trying to give privacy a constitutional backing. 21B never materialized. So self-regulation, in my opinion, is probably the best way out for the time being, so long we have a legislation that talks about privacy in a realistic fashion, talks about privacy not only to legitimize surveillance, talks about privacy to grant privacy, because privacy is a constitutional imperative, it is a fundamental right. To conclude, and this is Greta Garbo, who probably is the biggest example of privacy that she sought for herself when she went into her reclusive state. And Greta Garbo said, I never said I want to be alone. I only said I want to be let alone. There is all the difference. Probably any presentation on celebrity right to privacy or whether the celebrity should at all have a right to privacy should be reminded of this particular thing, that I want to be let alone. This should be safeguarded, this should be guaranteed, this should be respected. Thank you.